of our webinars on the Law Commission's consultation on confiscation law. We'll just have a quick look at the agenda. We're going to start by me saying, as I always say, a few words about the consultation itself, and then move rapidly on into recoverable amount. And that's got a few tweaks. We'll talk in that context about available amount and the amount required to be paid. Then we'll move on to discuss time to pay and interest, and then into enforcement. And of course, enforcement falls into two areas. We've got assets and we've got the default sentence, which is one of the principal means of enforcement, as you will know. So let's move on. The consultation, as you will have heard me say previously, if you've listened to parts 1 and 2, this is a Law Commission document that was requested by the Home Office back in 2018. They're looking at part 2 of the Proceeds of Crime Act 2002. So that is confiscation in England and Wales. But one assumes that whatever they say will also be considered in the context of confiscation in Scotland, confiscation in Northern Ireland. The consultation paper runs to over 600 pages, over 700 pages if you include the questions. And there are over 100 consultation questions which you're invited to answer. Having said that, you're not invited to answer all 100 consultation questions if you don't want to. You can pick and choose the bits that you want to respond to. I always say nice things about this Law Commission consultation paper, because that gives me the excuse to have a little bit of a pop at it later on. Undoubtedly, there is a tremendous amount of valuable material in the consultation paper. Too much to cover in 30 minutes. Even over this longer commentary that I've split into parts, and there will be another part in a week's time, even over that longer period, I'm inevitably being selective, and there will be points in the consultation paper which I'm afraid I just don't mention. I'm sorry. There is also, unless you're really into this, too much to read in full, I would suggest. And so I would recommend that you try reading just chapter 1. Even that runs to almost 40 pages, but that will give you a flavour of the whole consultation and enable you to dip into the remaining chapters which might be of interest to you. In practice, there are some useful ideas in that paper which could be implemented immediately because they do not require any change in legislation or even primary or secondary legislation. And there are plenty of suggestions which could be implemented without primary legislation, quite a lot even without secondary legislation. So let's get into the meat. Recoverable amount. Now, the present position is relatively straightforward. I think section 7 deals with recoverable amount, and it says in effect that you start with the benefit, and if the defendant shows that his available amount is less, then the recoverable amount is the available amount. So far, so good, so straightforward. The burden, as you'll see from that, is placed squarely on the defendant to show to the court that his available amount is less. So what do the Law Commission say? Well, they suggest a change of emphasis in the statute by a rewording of subsection 2 of section 7. And what they suggest is that it should refer to where, having regard to all the circumstances of the case, the defendant shows or the court is otherwise satisfied that the available amount is less than the defendant's benefit. And what the Law Commission are saying here is that there is, what they're suggesting is a recognition of the case law in cases like McIntosh, where the court is not blind to evidence which comes not from the defendant, but from somewhere else or from the general circumstances of the case, that the defendant's available amount is less than his benefit. For example, if you've got a defendant who's a drug trafficker and he's caught in possession of drugs, those drugs, of course, are seized, they're destroyed. He's not going to have, if he's nothing else, he's not going to have the value of those drugs as part of his available amount. And indeed, we're going to talk about drug traffickers a little bit more, because what they go on to suggest, rather more radically, is that the value of criminal assets seized from a defendant should be considered to be a component of the defendant's total benefit, as they are now. But, and here's the but, the order should reflect that some benefit has already been seized or disgorged to the state or to victims, and so there should not be a double recovery. So what they're suggesting here is that although the figure should be in benefit, it should not be in the recoverable amount. So let's think about the drug trafficker. Let's think about somebody who's got, let's say, £20,000 worth of cocaine on him. He's arrested. That cocaine is taken away from him, of course, and destroyed. He won't get that back. Now, that £20,000 is clearly benefit. But what they are saying is that if there are no other items in their case, let's just keep it that simple, he has nothing else, then to say that he has a recoverable amount of £20,000 would be contrary to common sense, because he doesn't have that benefit. He clearly hasn't got that benefit because those drugs have been taken off him. So what the Commission is saying is that in deciding the recoverable amount, the court should use a slightly different criterion from in deciding the benefit. I hope that made some sort of sense. The Law Commission don't lay a great emphasis on the amount ordered to be paid. And in my view, that's a little bit of an unfortunate omission. I think it follows perhaps from the statute itself, in that the statute sets out what the benefit is. There's sections that deal with benefit. There are sections that deal with available amount. In particular, section 9, of course, deals with available amount. There's sections that deal with the recoverable amount. Section 7 deals with the recoverable amount. There isn't actually a section that deals with the amount ordered to be paid. Now, you might say, well, the amount ordered to be paid is the recoverable amount. Well, no, it needn't be, because we have issues of proportionality to consider. The Weyer case and the amendment to subsection 5 of section 6. So when we've arrived at the recoverable amount, we're not at the end of our journey in terms of deciding what should be in that confiscation order. And indeed, the amount ordered to be paid has relevance, I would suggest, in relation to variations, to revisits, to reconsideration. So I think the amount ordered to be paid needs to be recognised by practitioners and by courts as a matter separate from the recoverable amount, separate from the available amount, separate from the benefit. There's no discussion in the Law Commission's consultation about where proportionality should impinge. Now, in practice, we know that in Weyer, the Supreme Court was looking at the amount which the defendant should be ordered to pay under the confiscation order. And in discussing A1P1, they're talking about the state taking property from the defendant. So that's all about the amount ordered to be paid. And they said, well, the amount ordered to be paid should not be disproportionate. And if we look at how POCA has been amended to reflect that decision in Weyer, we can see that the steps are: you calculate your benefit, you calculate the available amount, you calculate the recoverable amount under section 7, which is the lower of the benefit and the available amount. And then subsection 6.5, the court considers whether it would be disproportionate for that amount to be ordered to be paid. And if that is a disproportionate amount to order to be paid, then the confiscation order has got to be reduced to a proportionate figure. So under statute, proportionality comes right at the end of the process. It doesn't reduce benefit. It doesn't reduce available amount. It doesn't reduce recoverable amount. It reduces the amount ordered to be paid. Now, in practice, what do FIs do when they're preparing Section 16 statements? Well, in practice, what they tend to do is that if there's a benefit which has been repaid to the victim, they reduce their benefit figure. Now, that isn't actually what the statute is saying they should do. But pragmatically, it makes a lot of sense, because suppose you've got somebody who's got a benefit of £100,000, and part of that is a theft of £20,000, which he's actually returned. So the £20,000 is part of the £100,000 benefit. Suppose he's got an available amount of only £50,000. Well, he's going to be ordered to pay £50,000, isn't he? Is that disproportionate? No, it's not, because he's got other benefit of £80,000. But if he comes to be revisited under Section 22, is there going to be a record on the court's record of the confiscation of the fact that of that £100,000 benefit, £20,000 was repaid, and so it would have been disproportionate to order him to pay £100,000? Well, maybe there isn't, but if the FIs deducted it from the benefit, then that will mean that he won't be ordered to pay a disproportionate amount of money on a revisit. So what the FIs do in the Section 16 statements is actually entirely sensible and pragmatic. It's just not what the statute says. Okay, time to pay and interest. Let's look at that. Now, the consultation appears to view these issues in the context of enforcement and in the context of the overall UK or England and Wales value of outstanding confiscation orders. And we know there was a report from the National Audit Office a few years ago which said there is a staggering figure on the books of unpaid confiscation orders. And the Law Commission have looked at that and have approached time to pay and interest with that very much in mind, and have perhaps looked for ways in which that staggering national total might be reduced so that it's not quite so embarrassing. But it seems to me that a different set of issues might have been highlighted if the Law Commission had instead focused on the individual defendant's position in dealing with a confiscation order made against him and the statutory provisions regarding time to pay and interest. And I'm going to suggest there might be a couple of points that they've not picked up. Time to pay is initially no more than 3 months, as we know, with a potential extension of a further 3 months to be no more than 6 months after the date of the confiscation order. That's in statute, but one might ask, is that realistic? If a house has to be marketed and sold and payment received and paid into court, is it realistic to expect that to happen within 6 months of the confiscation order being made? I would suggest that in many cases, that's not realistic. And is it realistic then to charge interest commencing after so short a time? Particularly where an order is based on a defendant's entire available amount, as they often are. So if we've made an order against the defendant for his entire available amount to be paid, let's say within 6 months, and that includes the sale of his home, and he doesn't get the home sold quickly enough, with the best will in the world, he doesn't get the money in quickly enough, the mortgage settled and so on, the money into court within the 6 months, then interest is going to be added to the amount of the confiscation order. But kind of by definition, we've already said the confiscation order is in an amount which financially wipes him out. So how has he got any possibility of actually paying that interest? So is it realistic here to start charging interest after 3 months or after 6 months? The Commission look at whether interest should be stopped after a particular time. They don't look at when it should start. And time to pay is expressed in the statute to run from the date an order is made. And that's the word in section 11, the date the order is made. But in practice, what courts do is they treat this as a reference to the date on which the order is made or varied. I suppose strictly, if we just look at POCA, just at the words on the page, then there are no provisions that say what time to pay should be when an order is varied. They only talk about time to pay when an order is made. That's important because, of course, interest commences to run from the due date. So if we've got, say, a situation in which we are doing a section 22 variation of an order that was made 5 years ago, and as a result, the defendant has to pay more money, well, it would be crazy to suggest that the interest should run from the date the order was made 5 years ago when he wasn't due to pay. The interest has got to run based on the date the order was varied, even though it doesn't say that in the statute. And similarly, what courts do is they tend to regard themselves as having the authority to allow the defendant 3 months after the date the order is varied to make payment, or a further 3 months after that. In other words, all those provisions that apply to when an order is made are in practice applied by the court also to when an order is varied under section 22. The rate of interest, well, the rate of interest is 8%, and that hasn't varied since 1993. Is that a realistic rate today? By today's standards, that sounds like a penal rate of interest, and the interest is not intended to be penal. It's intended to be an encouragement for the defendant to pay, but it's not intended to be a punishment. And I've sort of touched on the interest accrued where a confiscation order is varied. And there's a kind of puzzling thing goes on where a confiscation is varied. Of course, you know that a confiscation order can be varied by an application, usually by the defendant, where his available amount turns out to be less than was thought at the time the confiscation order was made. And the order can be varied under section 23. And there's no time limit for that, so long as it's varied before the order is fully paid off. And of course, if the order is fully paid off, you don't need a variation under section 23. So 12 months, 2 years after the order was made, the defendant might come along and say, I've sold my house now. I didn't make what I thought, what I hoped. My available amount is reduced. I want to vary the amount I have to pay by making an application under section 23. Fine. What happens to the interest? What happens to the interest that's accrued since the order was made. Well, mystically, the accrued interest evaporates. Now, again, that's pragmatic. If we're saying that this defendant has only got X pounds to pay his confiscation order, then X pounds is what we're going to get. X pounds is what we ask him for. And we shouldn't be asking him, should we, for X pounds plus interest, because we've accepted that he's not able to pay it. But as far as I'm aware, there's nothing in the statute that actually authorises the court to dispense with the interest that's accrued on a Section 23 variation. Perhaps there ought to be. What about on the Section 22 variation? Well, again, there's nothing in the statute, but here the accrued interest pragmatically, again, you might say, continues unaffected. So there's a contrast between the treatment of interest on a Section 23 variation and on a Section 22 variation. In fact, one might also almost suggest that a defendant might be well advised, if he's got a lot of interest rolling up on his confiscation order, to go for a Section 23 variation, and perhaps if he can get the figure reduced just by £1, all the interest might disappear. Well, it's pragmatic, but legally, does it make any sense? Moving on to enforcement. The present situation, as we know, is that a confiscation order is an order in personam, and against the person, it's not against the assets. And it's for the defendant to take the initiative to realise his assets, if necessary, and make payment. In practice, although enforcement receivers can be used, they are seldom used because it might be regarded as a somewhat cumbersome and expensive procedure to get an enforcement receiver in. And the thinking very often is that the defendant actually might get a better price for his assets than an enforcement receiver would. But the system has been criticised as ineffective. So the Law Commission raised some possible changes to introduce what they term contingent orders. And what they're saying here is that when the confiscation order is made, the court could at the same time make a contingent order, let's say, to appoint an enforcement receiver over a particular asset 6 months from today, if the confiscation order hasn't been paid. The idea here is that the defendant would know from the get-go that if he doesn't get on with realising the assets, then this contingent order will come into effect and it will be done for him and it'll get worse. So it's another means, if you like, of encouraging the defendant to get on with realising his assets and paying off the confiscation order. And they also suggest that perhaps in some cases enforcement should be dealt with in the Crown Court rather than in the Magistrates' Court. Again, as you will know, the present system is that the confiscation order is treated as if it were akin to a fine, and the enforcement of that payment is then a matter for the Magistrates' Court, not the Crown Court, where the confiscation order was actually made. So the Magistrates' Court get it, as it were, from new, and at that stage asked to pick up the case and enforce the order. And the Law Commission say, well, actually, sometimes it'd be sensible to do that in the Crown Court. Well, yes, seems like sense to me. They also suggest that in appropriate cases, the Crown Court could allow interest to be stayed and orders to be put into abeyance where there is no realistic prospect of collection. So what they're saying, if you like, is that if attempts have been made to get the money in for the confiscation order, perhaps years have passed, we're not getting anywhere, then the Crown Court could decide almost to let the confiscation order lie on the file, something akin to that, to be reactivated if need be when there is an indication that the defendant has some assets and there might be something worth going after. Again, to me, this seems to be a means of dealing with the embarrassingly large national figure of outstanding confiscation orders. Part of the logic of this is that if nothing is done, those old confiscation orders, which, let's face it, are not being paid, are simply growing by 8% per annum as a result of interest. So this embarrassing huge debt figure is growing by 8% per annum, even if in real sense, it's not growing at all. Even if everybody in 2020 paid all their confiscation orders on the nail in full, the debt figure would still grow by 8%. And what the Law Commission are saying here is, in effect, maybe there should be a system for just saying, hey, we're not getting that. Let's just put it on a shelf somewhere. Another idea they've come up with is that, as we know, except in the case of the very largest default sentences, the ones over £10 million, the defendant is, if he is required to serve the default sentence, he is released at the halfway stage. And that's the end of it. So that the default sentence is in effect a half a default sentence. What the Law Commission is saying is, well, shouldn't there be some conditions attached to that release at the halfway stage of the default sentence, to say that if the defendant continues to fail to cooperate in settling the confiscation debt, then he can be pulled back into jail to serve the other half. Well, it's an idea. However, in my view, the Law Commission have missed opportunities to highlight the difference between Section 35 of POCA, which refers to the default sentence when a confiscation order is made, and Section 39 of POCA, which refers to the position where a confiscation order is varied. And I was saying before about time to pay, there's nothing in the legislation about what to do when a confiscation order is varied. But in relation to default sentence, there is a section that deals, Section 39 deals with what to do about the default sentence where a confiscation order is varied. And that might be a variation, for example, into Section 23, where there's a reduction in the amount to pay, and there may need to be a reduction in the default sentence. And a variation under Section 22, where there might be an increase in the amount to pay, and there might be a need to increase the default sentence. The slightly bizarre thing about Section 39 is that it refers to Section 139 of the Sentencing Act. And indeed, under some amendments which are coming into effect on the 1st of December, it will be referring to the corresponding section in the Sentencing Code. And that, as we know, is not the table of default sentences which applies under Section 35. So looking strictly at the statute, under Section 35, you've got one table of default sentences where an order is made. Under Section 39, you've got a different table of default sentences where a confiscation order is varied. And that doesn't, to me, make any sort of sense, but it's not a point which the Law Commission have picked up in their consultation. And similarly, if you are in a situation, let's say, where there's a Section 22 revisit, the defendant now has a higher available amount than he had at the time the confiscation order was made. There's a variation made to the confiscation order, to the amount ordered to be paid. This is the significance of the amount ordered to be paid. There's a variation to the amount ordered to be paid under the confiscation order. Let's say his original available amount, his benefit was, say, £2 million. his original available amount was £500,000. He was ordered to pay £500,000 originally. There was a default sentence set of, let's say, 5 years. That was some years ago. That all happened some years ago. Now he's been subject of a revisit. His available amount has increased. He's now got an available amount of more than £500,000. And he is ordered to pay a further amount by an amendment to the amount ordered to be paid under the confiscation order. So the amount ordered to be paid was £500,000. It's now going to be £500,000 plus whatever extra he's ordered to be paid. He's ordered to pay. Now, default sentences don't work in linear bands. Suppose that he's now ordered to pay £700,000. If he had a 5-year default sentence under the original confiscation order, he is unlikely to get a 7-year default sentence, which would be a pro rata increase, on £700,000 to pay. And if he's already paid the £500,000, then the default sentence, the new one, is only going to be, the time that he might risk having to serve is only going to be a proportion, isn't it? Because of the amount ordered to be paid of £700,000, he would have already paid 5/7. So the default sentence in practice is going to reduce to 2/7 of whatever the court says the default sentence should be. And it all becomes higgledy-piggledy and a mess and potentially unfair. And again, these are issues that have not been highlighted in the Law Commission's consultation paper. Okay, it's come to 3 o'clock. Let me briefly run down, as you will have heard me say before, how Bartfield's forensic accountants can help. We remain fully staffed in this new lockdown. We're continuing to undertake legal aided and privately funded criminal and civil forensic accountancy work. Fortunately for us, it's relatively easy for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities. And of course, we remain readily contactable by phone, by email, and online. Our website is full of useful information. One of the blogs that I've put on there recently deals with those items within the consultation, which I've called them 7 quick wins, which could be implemented without parliamentary involvement. You can find more on this topic on our website, and this and previous webinars will be available. The link is there. This webinar is being recorded. It'll be available and the slides will be available in a few days. If you have any questions, do please email me and I will try my very best to answer. My email address is there on the screen, and there is the phone number and the website address. I will be back in 1 week's time to deal with part 4, which I think will be the final part of my discussion of the Law Commission's consultation on confiscation. So I will hope to see you in 1 week. Thank you very much for your time, and goodbye for now. Thank you.